Hello, everyone. I'm Richard Fink, a lawyer in Ontario who specializes in workplace safety and insurance board law. And today, our podcast, which is the legal side of workers' compensation, is going forward. Paul?
Hi, my name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario. I specialize in human rights and workers' compensation matters in Ontario, just like Richard. If you want to reach out to either one of us or be part of our podcast as a guest speaker, you can contact us through the links below. This week's topic is paper doctors. Oops, paper doctors. Let me explain what I mean by this term. Paper doctors is when the board will hire what's called as an independent medical examiner because in Ontario, the WSIB, Workers' Compensation Board, no longer has doctors on staff. I believe they only have one. So what they do is they outsource this work to where they'll hire a doctor as a consultant to review a file. And the problem with this is the reason why we call them paper doctors is they only do a paper review. But as you'll find and you'll hear, is a lot of the times the doctors are contradicting an injured worker's doctor's opinion or specialist, but yet they've never examined the injured worker.
So let me give an example in a case we did. The worker is fixing watches, wristwatches. And to fix a wristwatch, you have to use chemicals. And the worker's ventilation system in the factory where he worked was inadequate. And he claims he got poisoned by the chemicals and was having trouble thinking and breathing. The WSIB sent him to see their neurologist, who was of the opinion that he might have a problem. The case manager wasn't happy with the word might. So the case manager got an opinion from another doctor without that doctor having examined the worker. So now the worker has been told, forget it, you've got no case. So they retain our firm and they pay us money and we send out the file and the worker to one of the specialists in chemical poisoning in the province of Ontario, who I think works for OCHOW or did work for OCHOW, which is a group of doctors and others looking at chemical problems. And they determined that indeed he was poisoned. The case went all the way to the appeals tribunal, so it took 3 years to get there and a decision. They allowed the case. It then goes back to the WSIB, and the question now is he still symptomatic from the problems? Is he still having problems from having been poisoned? And they do not send him to a doctor. They send it to the same doctor who said there was nothing wrong with him in the first place. He was never poisoned. This doctor then sends in a report saying there's nothing wrong with him now. And I had to tell the worker, for us to appeal the case, we need to have you seen by the same specialist doctor who did the original opinion and see whether you're still suffering from the problem. And the worker's still suffering. There's no doubt about that. I said, alternative is go see a psychologist and find out whether you've got chronic pain disability, which is a psychological condition from having been poisoned. And the worker, after hemming and hawing for about a year, said, forget it, I'm not paying any money for doctors. Mr. Fink, you're not a good lawyer. Goodbye. So the case is quite heartbreaking on a number of planes, but one of them is the doctor who's doing the opinion never saw the person. I mean, if he thinks this person's got all these symptoms, see him. And if you think he's just faking or something, or he's got psychological problems, tell us.
Yeah, that's typical. And one of the points that I've noticed, this keeps coming up, as you've noticed, Richard, where I bring up this single case, and that is the WSIAT decision in 1229-19 at paragraph 66, which lists the test for weighing medical evidence decision makers to do. And one of those criteria talks about objective evidence. And this, as a rep, and injured workers will hear this term of objective evidence. Where is there objective evidence from a paper doctor? It's clearly subjective, meaning subjective is their opinion, objective is concrete evidence. I always explain this to people. Objective is, or subjective, it is cold outside, where that's my opinion, and then objective is it's minus 20, which would be cold. But so that's very interesting because in this decision, we come back to this decision again and how the board seemingly is going with evidence that they shouldn't, or they're not correctly weighing the evidence in a particular case. There's other criteria as well as quality, knowledge of the facts. How can a doctor say that they have knowledge of the facts of the case of the individual when they've never met them or examined them? So those would be the factors that I would check off when doing an appeal for an injured worker where they're denied solely based on a paper doctor's opinion, contrary to their doctor's opinions that were done, with a physical examination.
The second point is that we have cases where the case manager plays doctor. So one of the cases we had, which lasted 11 years, which itself is very insulting to the injured worker. The injured worker is working in a chicken factory, uh, disseminating pieces of chicken, cutting chickens, gathering up chickens, hanging chickens, cleaning up floors with chicken pieces. And they do this job for about 6, 7 years, and they start to have problems in their finger and wrist. And the WSIB doctor says, I don't see this as being related to work. It's a pre-existing condition, and they deny the claim. So off it goes through the appeal system. And in the appeal system, they said, yes, you have a disability from work, but then they cut the worker off benefits by saying, these conditions get better, you should be better, we're cutting you off, you have no problem. Then the worker appeals that. A whole bunch of doctors that are treating her say she does have a continuing physical problem in her wrists. The board then says, yes, we agree you have a physical problem, but it's not so bad you couldn't go back to work and pluck some more chickens. The worker says, I got terrible pain in my hands. There's no way I can start maneuvering chickens. Then goes to the psychological side, which again, the board denies without having any psychiatric opinions on their own, saying she's not psychiatrically affected by all this. And back it goes through the appeal system. And takes the 11 years for the board to say, yes, you can't work and we'll pay you to age 65. So in this case, what we have is medical opinions not based on what seeing the worker. And we've got the case managers playing the role of doctors. In other words, they can differentiate medical opinions and they can provide decisions based on their medical opinions. It's a very dangerous situation.
In that topic, again, I revisit the decisions of the divisional court. The divisional court is where an injured worker would go in Ontario after appealing and reconsidering a decision to the Workplace Safety Insurance Appeals Tribunal. And there's two cases that come to mind. In Fiera v. WSIAT, it's 2019 ONSC 3437. I can't speak today. In that decision, the panel members thought, and this you'll probably see covertly with decision makers at the board and tribunal, is where they won't openly say it, or sometimes they do, is that they think the worker is faking. They have no proof of this, So then they'll take action, which is illegal, is an error of law. And in this case in Fiera, they thought the worker was faking, even though the board said that no, they didn't think he was. And there was all kinds of medical evidence proving the individual wasn't faking. The panel members ignored the evidence and then said, he's fine. And in doing that, the divisional court said that the panel members made a jurisdictional error and reversed the decision. In another interesting case called McQuid, McQuoid v. WSIAT, this one was interesting because it was a little different in that there was medical evidence, but it was delayed. And it's curious in the sense of that the board said, no, we don't think it's work related or anything, even though there's medical evidence proving it, but there was a delay factor. And this is very common, as you were just talking about, in repetitive strain injuries, physical injuries, and then also in chemical exposure injuries conditions. And in those, it's a delayed onset. And seemingly, sometimes the border tribunal will ignore the fact that it's the delay effect that the person doesn't know. And that's where the divisional court agreed and overturned the WSIAT's decision in that too. And I mean, in both those cases, the problem is instead of like in the 1229/19, instead of the decision maker being the case manager, appeals officer, or panel member, instead of them weighing medical evidence, they were literally putting their own opinion in its place. That's why we have lawyers, paralegals, courts, and judges, right, Richard?
Yeah, the problem isn't so much that the decision makers are anti-worker or anti-worker who's injured, but they have a degree where they're skeptical of problems. So the skepticism comes into play rather than trying to balance the evidence in front of them.
Yeah, their emotions take over.
Yeah. Let me
And
give one more example of a case
sure.
we're currently doing. The worker is a teacher who gets hit on the head with a 5-pound block dropped by a student and suffers a concussion and claims they can't go back to work. They have headaches, they have memory problems, they're not functional throughout the day. They can't return to school. The employer, which is a school board, hires a private investigator and they find the worker is able to drive her son to a hockey game. The son is, 10, 11, 12 years old. Drive the son to a hockey game, which is about a 15-minute drive one way, and can sit for the 2 hours it takes to play the hockey, get dressed, and uh, finish the game. And the board's position was if you can drive to the hockey game and sit there with other parents, you're all recovered from what is a relatively minor head injury. She didn't lose consciousness when the block was dropped on her head. The worker has been examined by 3 specialists, neurosurgeons, neuropsychologists, and neurologists. And all of them examined the worker, and all of them said, this worker still is symptomatic, notwithstanding the videos we've seen of her taking her son to the hockey game. The employer hires a neurologist who says it's a minor injury. Everyone should recover within 3 months. The fact that the worker can take their child to a hockey game shows that they have pretty good ability to do things. Um, the neurologist says I haven't examined the worker, so I don't know if in fact she's having memory lapses. I don't know if in fact she's having headaches, but her headache should have resolved by now. There's nothing on her CT scans. The SPECT scans that a lot of neurologists use to see that the brain's not operating properly, they're useless, but that isn't exactly what the appeals tribunal has said about SPECT scans. They said they're helpful, but not determinative. And her view was, taken all together, this worker can work. And this is the opinion accepted by the board. So now it's going to the tribunal, and they're going to have to weigh the videos, the employer's neurologist, the three doctors who's treated the worker, and the worker who never bothers to tell the board, oh, by the way, I can drive, for half an hour a day from time to time. Um, these cases are surely a conundrum to the system, and I wish I had a clear path to making things easier.
You know, Richard, you bring up a very good point about driving and abilities. I mean, very quickly, I'm going to talk about David Curtis's case at the Court of Appeal because I was there. And his example to the judge, he was self-represented and he was in his 70s, I think. So it was quite, he's one of those outspoken individuals. So it was quite humorous at one point in the court. And what it was is he had a back injury and arm injuries. And he was sitting at the front because he has a hearing problem. So when he was talking to the panel of judges, and this is an old building, you've been there, and he's sitting at the front with this nice oak table. And he's saying to the judges, like, I'm not dead, I can still function. It's just certain things I can't do. Like, I can lift things, but I can only lift them a certain way. And he goes to get up and he goes, look, I can lift this table. And the judges go, no, no, no. And everybody started burst out laughing. In David's case, though, he was at the Court of Appeal, not appealing benefits. It was the employer had hired a private investigator and got his neighbor to say that he was fine based on her observations of him. And in that case, based on that, the board suspended his benefits, incurred an overpayment of like $160,000, and then went so far as to prosecute him in provincial offenses court. They wanted 6 months in jail, they got 6 months probation. In the end, the Court of Appeal said that there was no mens rea mental intent in that charge for David's case, as well as the two other injured workers that were there. And it was what I would call as a landmark decision because when I was reviewing cases at the Human Rights Tribunal, I remember reading a decision from the WSIB where an injured worker was fighting them, and the board said that they were withdrawing their provincial offenses prosecution of the injured worker because of the R.V. Curtis case. It was quite interesting, and that was a case that I eventually ended up representing at the tribunal. But the concern that I had with the whole case was even the judges did like the panel members and the case managers, where in the one case that the trial judge literally ignored the medical evidence and put his own opinion in its place. And you can't help but keep coming back to that point of there's a problem, where people are just literally ignoring the medical evidence. Like I was of the impression when you're dealing with a medical condition, you have to have medical evidence. And having a neighbor saying, well, he's fine, or in other cases, a case manager saying, well, you look fine to me, and even measuring, well, you can drive your car to the store, so you're fine. Like another example you'll hear often, Richard, is dealing with truck drivers. If you can drive your car, then you can drive a truck. Well, first of all, the comparison is moronic, or it's apples and oranges, because driving a truck, you have to climb up 5 feet, you have to hook and unhook the lines, crank the trailer, and all that stuff. Actually now most trucks are actually automatic to accommodate the drivers. But my point is that it is considerably different than driving a car. More importantly, when you drive your car, you can limit your ability to driving anytime. You can just, I'm not well, so I'm not going to drive. When you're forced to work, you can't do that. And this is something that is missed with the board, especially with taking medication. Many workers are on impairing medication, and the board is saying, well, you're driving to here or there. Yeah, but I'm not impaired by the medication. It's just, and they go, well, we don't get it. Okay, well, if I drink 6 beers last night, I can't drive legally. But then today, after sober, I never drank 6 beers, I'm just saying. But then today, I'm sober, I'm clean, I'm fine, I can drive now. And it's that concept of sometimes I can drive, sometimes I can't, that the board seems to miss. And I think that's part of the problem with that case that you have
Uh,
as well.
the scales of justice are a little tipsy-turvy, as shown on your office wall. But
Yeah.
we have
Actually,
to end today's podcast on that note.
I don't know if you can see
Oh,
it, but
look,
there's
you've
my
got a
scales.
second. Yeah. Well, good. I
Yeah.
see you're balancing things.
Yeah.
So I thank everyone for joining us and see everyone next week. Take care.
Yeah. Bye, everyone.